The question before the court currently is, did the trial court err in ruling that the Board of Elections, in fact, had jurisdiction to consider the specifications of objections to appellant's candidacy in light of the fact that they were not served in accordance with the mandatory service provisions? We submit that, in fact, the trial court did err in making such determination. The relevant rule is 9 CRR and Y 62041B, which the Board of Elections binds itself to, and it states in relevant part that no specifications of objections will be considered by the Board unless such objections are personally delivered or sent via registered or certified mail on or before the date of filing. There was a certified mail package sent to appellant.
With objections to a different candidate's nominating petition.
Correct.
Okay.
So why does that matter how it was served?
Because the rule...
What if it was a grocery list? It was not the right specifications, correct?
That is correct.
Did your client comply with the rule?
Our client substantially
No,
complied.
did she comply with the rule?
I beg your pardon?
Did she comply?
Yes, she substantially complied. The return receipt request indicates the card was received. The overnight
But she
mail...
received objections regarding a different candidate.
Yeah, correct.
Does that count for anything?
No, excuse me?
Getting objections regarding a different candidate? What does that mean?
No.
The case law is pretty consistent as well that there is no trying when it comes to service. You either serve or you don't. And in fact, they didn't. In the matter of Del VR versus Vecchiarellis and many other cases, there's language that says methods of service that are jurisdictional in nature must be strictly complied with. In Rosen v. McNabb, Court of Appeals case, the substantial compliance, if there was any in that case, related only to the form of the petition. It was the candidate's compliance, nothing to do with service or the objector's duties under the rules. That related to ballot access, not ballot removal, and again, it's not germane.
So in this case, you'd be using substantial compliance to block ballot access of Ms. Neal.
They would be using, right. And the election law creates a presumption of validity, and so the burden is on the objector to invalidate, not the other way around.
Right.
And so in order to invalidate, the higher standard that must be met. It's not substantial compliance, they must strictly comply with the rules. With the correct...
You say it was sent a day late.
Yes.
Are you conceding that its inclusion in the petition would suffice as long as your client otherwise gets it?
It would have to be sent in the right method. So if they're going to rely on that, UPS would not do the trick because the regulations specify it has to be certified or registered mail.
Okay.
I apologize if I'm confusing the court. The subsequent mailing was received on the very same day that the first mailing was received. There's no dispute she received them on her front door on the same day at 9:03 in the morning.
And what, in fact, did your client do?
The record, I believe, because we did not dispute this point, was that a mailing was sent to the candidate by regular mail, that...
With objections to a totally different
candidate.
candidate. Do you agree on that?
We're not disputing it, Your Honor, because the fact of the matter is when we questioned the person who did the mailing on behalf of our office, they didn't know. The controlling law is the Conti case, decided by this court in 2014, which articulated, as long as there is no prejudice to the candidate, minor deviations from service are excused.
We did show, in fact, that there was prejudice here because it was sent via a method that was unanticipated and not allowed by the rules.
Prejudice is, I didn't get it, I got it late, I didn't have time to prepare, to prepare an adequate defense to the thing.
But she did discover it late. There's nothing in the record to suggest she discovered it when it was dropped off on her doorstep. The certified or registered mail provision is in place because that requires a recipient's signature. So that's how you validate that someone actually received the package. UPS delivery is not part of the rules for a reason because there's no telling when somebody might discover it, and there's no notice that might be a way that these specifications would be served. I also want to cite the case of Maniscalco v. Power, which is a First Department case, but it was affirmed by the Court of Appeals relating to this issue as well. And it says that the board ought not to have sustained objections which are not properly before it on the merits in view of the failure to comply with its own rules. And it says that the board's rule is consistent with the policy of fair play laid down by the election law. And
so enforcement of a rule is fair play?
Is fair play, correct.
All rise. This court is now adjourned.